We are following a big update in the case of a Connecticut mom who allegedly tried to kill her estranged husband by poisoning his wine with antifreeze. Kristen Hogan is facing new charges, and this time it's for alleged deceit involving her children. What new court documents unveil about the questions that have gone on for years about who the father is of her children and why those questions are now leading to new charges. We're on the case, presented by Law&Crime. I'm Chris Stewart. Hey, real quick, before we continue on with this episode of On the Case, I want to talk about Morgan & Morgan, America's largest personal injury law firm, a major sponsor of On the Case, one of the most watched shows on YouTube. Morgan & Morgan has more than 1,000 attorneys who have recovered $25 billion for more than 500,000 clients. In the past few months alone, a client in Florida received $12 million when insurance offered just $350,000. In Pennsylvania, another client was awarded $26 million. That's 40 times the insurer's offer. Morgan & Morgan makes it easy to fight for what you deserve. You can even start a claim from your phone. So if you're injured, you can start a claim at forthepeople.com/OTC. You can also click the link below or scan the QR code on our screen. A Connecticut mom who lived in a Ritzy, part of that state, in a home worth more than $1 million is accused of going to extreme lengths to kill her husband by poisoning a wine bottle with antifreeze when he wasn't home. But this apparently is just part of the story, allegedly. Now, this is video of Kristen Hogan when she appeared in Connecticut court on attempted murder charges in October. She's currently on house arrest after posting a bond of $100,000. It appears this woman comes from a lot of money, and it also appears that she's had some issues for years related to her two children and the question of who their dad is. And that is apparently leading to new charges. Now, before I get into that part of the story, let me remind you how Kristen's story became national news. Kristen Hogan lived in Ridgefield, Connecticut. This is a ritzy town right along the CT New York border. And the house that she was living in, the address that she and her estranged husband lived at, the home was valued at more than $1 million. This is her mugshot. She was arrested in October, and it was the culmination of an investigation that started in August. Well, the investigation into attempted murder charges of her estranged husband. Now, Hogan has been in a bitter custody dispute with her estranged husband. The two of them, they share at least one child together. Now, Hogan told police they've been separated since May of this year. She says that it was so bad that her estranged husband actually had her car towed from her possession because it was in his name, and then she had to move in with her parents. The address for her parents is a home that's worth more than $3 million, by the way. But we are learning that the issues with Hogan, they go back years. Now, before we get into that, I want to start with what happened on August 5th. Hogan's estranged husband said that he had family over and someone brought a bottle of wine. They didn't finish the wine that night, so they corked it, they put it away. 2 days later, that estranged husband and Hogan, they were due to be in court because Hogan, the female, she had filed a complaint. Hogan did not show up to that court hearing, though, even though she was the one who filed the complaint to have the hearing. The man said while he was at the courthouse waiting for Hogan, he gets an alert from his Wi-Fi router at his house that Hogan's phone was allegedly inside. When the alleged victim got home, Hogan wasn't there. So that was August 5th. Let's go 5 days later, August 10th. The estranged husband says he had some of the wine from the dinner party a few days earlier, and when he woke up in the morning, he was vomiting and he had to go to the hospital. Doctors actually thought he was having a stroke at first because he was slurring his words. He could barely stand. That's according to Connecticut State Police. Now, State Police tested that wine bottle, and it came back positive for traces of a key ingredient in antifreeze. And that allegedly wasn't the only thing in the home that had that alleged poison in it. Now, as this part of the story was developing, on September 29th, the man called police to tell them that the child that he shared with Hogan was in the hospital. That child was allegedly showing similar symptoms to what he had dealt with. Hogan allegedly told social workers that her estranged husband could be poisoning their child. Now, based on those allegations, the estranged husband was actually removed by hospital security. Police then start talking to Hogan, and she told them that she believed that her estranged husband was poisoning her child. And she also said that she was living with the man full time, and according to the estranged husband, that just wasn't true. But she did have full access to the house. Hogan told police that she didn't go to that court hearing for the complaint that she filed because she says she was with her family in Rhode Island. Now, that was the day that Hogan's phone, remember, was allegedly inside of the house. Then police told her what they found in her search history, and this is where the story gets stunning. Hogan allegedly searched for potassium cyanide, potassium ferricide, citrate cyanide, potassium thiocyanate, and monoethylene glycol. On top of that, she allegedly searched just how much of those substances, quote, would kill you and where you could buy those substances. She reportedly searched several measurements like kilograms to pounds, and she apparently wasn't done. She also allegedly searched for, quote, penalty for not appearing for court hearing on your own motion. Now, this was all a day before Hogan did not appear at that hearing that her estranged husband was at. Now, when confronted about her search history, Hogan allegedly said she didn't know what police were talking about, and she only recognized the word cyanide, she says, from the show Psych, which you might remember, it ran on like USA from 2006 to 2014. Now, Hogan then, as the conversation continues, remembered, I put that in quotes, that she did buy monoethylene glycol in July on Amazon because she needed it to clean a carpet at her mom's house. Then police laid out their cards even more. According to court documents, they said, based on the Wi-Fi information, they knew she was inside her estranged husband's house, and they also told her how he was hospitalized with the same chemical that she said she ordered to clean her mom's carpet. So then it appears Hogan allegedly comes clean to an extent. She reportedly told police that she never intended to kill her estranged husband, but, quote, wanted to make him sick as payback for being mentally abusive. Now, I'll show you what her attorneys are saying about that part of this case in just a moment. Hogan then allegedly said she didn't measure how much she put into the wine bottle, and when asked if she put the alleged poison anywhere else in the house, she said she did in an iced tea bottle. She says there is no way her child or any other child could have consumed that tea. She claimed her search for how much of the chemical could kill you was after she learned her estranged husband was in the hospital, not before. Hogan was arrested, and she is facing a charge of attempted murder for allegedly putting antifreeze in her husband's wine bottle. She is also facing a charge of interfering with an officer. Hogan appeared in court in that case with her attorneys, who said she was posting $100,000 cash to make bond. Again, it appears this woman comes from a good bit of money. She also was allowed to go live in Massachusetts on home confinement with her grandparents. The reason she was going out of state was because there is a Department of Children and Families order that does not allow her to be at her parents' house in Connecticut, the more than $3 million home where she was living. She will be wearing a GPS monitor, and she will also be meeting with a parole officer once a week. Hogan went to a hospital to be evaluated for mental health issues before she headed to Massachusetts after posting bond. Now, in that case, Hogan is not slated to be in court until next year. But there's a new case this mom is facing. Kristen Hogan turned herself into police in Connecticut on December 11th, and this is her new mugshot. Hogan's new charges are 3 counts of perjury and 1 count of tampering with evidence, and this is why. State police say when they arrested Hogan on attempted murder charges, they discovered that she was allegedly involved in what they called a, quote, deceitful act related to a custody battle involving her children. We found Connecticut court records that show there have been some major questions of who the father is of her 2 children. Police say Hogan gave birth to her first child in September 2020. Court records show that Hogan was married to a different man from March 2020 to October 2021. Police say a paternity test showed that that man was not the father of her first child. Her estranged husband, who she allegedly tried to kill with antifreeze in the wine bottle, is the father of that child. Hogan then gave birth to her son the same month that she was divorced from the other man in October 2021. Police say Hogan claimed that she knew who the father was, but she would not say his name. Now, this led to a dispute and DNA testing was requested. Police cite a public investigator that followed Hogan to the DNA appointment in April 2024. The public investigators say they saw Hogan bring a boy to that appointment and then followed her for hours after that. The testing came back and showed that not only was her estranged husband not the father of that child, but that she was not the child's mom. How does that happen? This is what police say. Police claim that Hogan brought her nephew to that appointment, not her son. So that is the alleged deceitful act that we're talking about. And on top of that, police say the surveillance showed that Hogan's mom was with her when she goes to this DNA appointment. But Hogan's mom's attorney denies that her client was aware of her daughter's alleged plan to bring her sister's son to get a DNA test to allegedly throw everyone off the trace. Not only that, state police say they spoke to Hogan's sister, who is the mom of the boy that was allegedly brought by Hogan to this DNA test, and she said that she had no idea that her sister would allegedly do this, and she also said she does not believe that her mom would be involved in this alleged plot. Hogan, on these new charges, was held on $50,000 bond, and she is slated to be in court in this case on December 23rd on these new charges. Join us now to talk a little bit more about this case, or should we say cases, because they're separate at this point. Criminal defense attorney Eric Faddis, it's always great to have you on Law and Crime. You know, reading through this, it was shocking because she's already facing really serious charges of attempted murder with what she was accused of doing to the wine bottle. But in this one, it really dives into some of the paternity issues that she's had, custody issues with her estranged husband and an ex-husband. Just what did you make of reading through what police have now charged her with?
Well, gosh, Chris, I think one thing that I've seen in terms of a trend is just how quickly things can escalate when the origin of these disputes is a custody case. That is something, it's so emotionally charged, it drives people to do outrageous things. And those are the allegations here, not only with the attempted murder, but then with these alleged deceptive activities in the family law case as well. The defendant is just digging herself a larger hole, and unfortunately not surprising in this heated custody context.
And looking at this, it seems separate at this point. We have the attempted murder case that is ongoing. She's due in court next year on that one. She's been out on bond. But then this one, she'll be in court on these new charges December 23rd. How likely is it that these will remain separate?
Well, you know, if I'm the prosecutor, I might explore whether it's possible to join these cases. There is really a common thread that runs through them. The familial disputes appear to be a motive for the attempted murder, and that is the context in which these deceptive DNA tactics allegedly occurred. It also involves similar parties. You know, the same defendant, the same family is involved. On the flip side, if I'm defense, I am trying to, as best I can, to keep these separate, because you don't want a jury in an attempted murder case hearing about some sort of alleged underhanded measures taken in the DNA case that appear to go to the defendant's credibility.
What goes into determining whether cases like this get combined?
You know, different jurisdictions have different rules on this. You know, in Colorado, where I practice, one potentially applicable rule is whether it is the same series of criminal transactions that gave rise to an ultimate event. And so here, that's kind of arguable, right? The DNA stuff happened, it preceded the alleged poisoning. And so, you know, will those be combined? If I'm defense, I'm saying, hey, judge, you should not combine these because it's going to have an unduly prejudicial effect on my client. Even if there is some relationship between the two cases, a jury is going to hear about this DNA stuff and might hold that against the client on the attempted murder charge. And so defense, I think, is going to really try to ensure that these cases remain severed to the extent possible.
So I also think if you were a prosecutor and you're trying to paint this picture of who she is in the attempted murder case, this person that would go to extreme lengths to allegedly try to kill her estranged husband. And I know her defense has said that this was actually a very, volatile, toxic back and forth with her estranged husband. But now you add in that she's accused of taking her nephew to present as her child for a DNA test. when it comes to what her character might look like in the attempted murder case, that would be really, really bad. Even if these cases aren't combined, can a prosecutor take, well, she's facing allegations in this other case, and this is what she's accused of doing. Can you take that and then add it into your case on the attempted murder charge?
Even if the cases remain separate, there might be some facts in one case that are relevant to the other case. And so here, as a prosecutor, you want to tell the whole story to the jury. You want to kind of start from the beginning and show how this escalated. What were the triggering events that gave rise to the alleged poisoning allegations? And the deception in the family law case is part and parcel of that. So if I'm prosecutor, I'm definitely trying to reference those events. And then also, Chris, if the defendant were to testify in the attempted murder case, I think that opens the door for these deceptive practices beforehand to come in, because it goes against her credibility. Prosecutors are going to say the jury should know about that.
What do you make of the fact that these deceptive practices that police are accusing her of, related to the DNA test, she's facing these perjury charges for it, tampering with evidence, it relates to something that happened in 2024. So it's been more than a year since all of that went down, or roughly a year since that went down. And then she gets arrested in 2025 on the attempted murder charge. And I guess it was after, just reading through what Connecticut State Police wrote, that it was like after they started investigating the attempted murder, they found these acts as well happening. What do you make of it kind of being out there, but she hadn't faced charges until now?
Yeah, that part is a bit curious. If the police had solidified information that she is essentially lying to a court through this DNA stuff, why not bring the charges earlier? The fact that they waited, I think, doesn't help the government. I think defense is going to look at this and say, hey, the government is sort of piling things on. They had an opportunity, if they thought that this was actually a crime, to prosecute her for that. They chose not to until national media attention came on this case. And now, lo and behold, they're trying to drop the hammer on her. So you can kind of try to make a fairness argument on the defense side that these charges, if they're valid, should have been brought a long time ago.
When she was arrested on the attempted murder charge, her bond was set at $1 million. It does appear she comes from money, it appears. I mean, just based off the house she lived in, the parents' house that she was at, the attorney she's been able to hire. She posts $100,000 cash. So she's been on house arrest ever since in Massachusetts. Could these new charges impact her bond conditions in the other case? If a prosecutor comes forward and says, hey, not only, is she accused of doing this with the wine bottle, she also at the same time did this with her nephew and her child. And according to the police documents that we read through, doesn't seem like her mom or her sister had any idea that she was doing this. She literally took the child, according to these police documents, to the DNA test without their knowledge.
If I'm the prosecutor, I am filing a motion pronto to try to increase her bond based on this development. And here's why. So in terms of a bond, whether a judge lets a person out on bond, one thing that is front of mind is whether they can trust the defendant to comply with court orders as the case is going on while they're out on bond. If I'm the prosecutor, I'm arguing, hey, she's shown not only can she not comply with court orders, but she will actively deceive the court to try and better her position. And therefore, she can't be trusted out of custody, and the bond should be increased. I wouldn't be surprised if such a motion was pursued on behalf of the government.
When it comes to family court cases, and so much of this was in civil, you go through court records and there's different motions that have been filed trying to test the paternity of the kids. It's been going on for years. How often does that transition from civil court into criminal court like what we're seeing?
Alarmingly often. Sadly, there are so many things that happen in these divorce cases that are inflammatory, that cross the line into illegal. People, it's high stakes, right? It's their kid on the line, and so they're willing to go to great lengths, sometimes too far lengths, to get what they want in that case. And here, there's allegations that she perjured herself and also essentially deceived the court in terms of the nature of the DNA evidence being provided pursuant to a court order. She knew the judge was going to look at this, and she tried to pull one over on him. That's a huge problem for her.
And I remember after her bond hearing where she was able to post this $100,000 cash, and her attorneys said after that she was going to go get her mental health tested. And you look, and I don't know her mental health situation. I mean, clearly there's been some alleged deception. There's been some issues that have gone on. I mean, to try and kill somebody allegedly by poisoning a wine bottle, that is in and of itself something that people on the outside would say there's something wrong with someone who would do that. And she's accused of it at this point. But what's the bar for there to be a mental health defense in the attempted murder case?
Gosh, it's a super high bar, Chris. It's not something like you see in the movies where people get off on not guilty by reason of insanity regularly. That's just not the reality. The bar is typically that the defendant had a mental disease or defect which prevented her from appreciating the wrongfulness of her conduct. She couldn't really distinguish between right and wrong due to the effect of this mental disease or defect. That's an extremely high bar. What is that mental disease or defect? Sometimes we talk about schizophrenia, bipolar disorder, that kind of thing. I'm just not aware of any such diagnosis yet made public in a case like this. But to say that she didn't know what she was doing was wrong, that's sort of undercut by the calculated nature of the deception in which she allegedly engaged by giving her nephew's DNA and passing it off as somebody else's.
When it comes to the attempted murder case, and you have not only just the bottle that tested positive for the antifreeze, you have the husband had it in his system, according to police. You have Google searches of the type of chemicals that are involved. She, to an extent, talked about it a little bit at the hospital as well. It seems like there's a lot of evidence that's against her. She has some, it appears, expensive attorneys that are on her side because she comes from some means. What are those attorneys probably doing right now as they're building their defense against the attempted murder charge?
Sure. So attempted murder, of course, is an extremely serious allegation. From defense perspective, you got to pick it apart. You got to look at the elements of it and say, hey, is there really enough evidence for a specific element? So for attempted murder, they've got to prove that she intentionally tried to kill somebody. That was her conscious objective, to try to kill him. And I think some of the reports have indicated that her defense might look like, hey, she freaked out and she made a horrible decision, but she just wanted to harm him. She didn't intend to actually take his life. And there are some reports to that effect. If that's the case, if defense gets a jury to buy that, that is a significantly lesser charge for which, a handful of years in custody might be rendered as opposed to decades and decades. And so it's really a big difference between attempted murder and something lesser, which I think they're going to try to argue to a jury.
How does that work where if she's charged with attempted murder and then let's just say it is proven because she did make a statement, something along the lines of like, I didn't want to kill him. And if that's really her defense and the jury buys that, is that she's not guilty of attempted murder? Or is it, how does it work that suddenly you're charged with something lesser than that? Because she still did, if all of this is true, put antifreeze in a wine bottle.
Sure. So in many jurisdictions, including Colorado where I practice, they have what are called lesser included offense and lesser non-included offenses. Basically what that looks like is if someone is on trial for attempted murder and they can't prove an intent to kill, but they can prove an intent to harm, that could bring it down to a lesser included offense of like assault. Now, assault in many jurisdictions, simple assault, is just a misdemeanor. Now, would it be assault with the intention to cause bodily injury? These are all nuances that can be parsed out at trial. But just because they can't get her on the hook for the most serious charge doesn't mean she's off the hook for other significant charges that might be lesser offenses.
Now, she was able to post, there's a lot of people accused of attempted murder who do not see the outside of a jail cell until their trial and if they're found guilty or innocent. In her case, she's able to post $100,000. What did you make of that? Because I know people will look and say, well, here's someone with money and they get off and are able to go home or not have to live in a jail while this case is going on. There's a lot of people that can't put up $100,000 cash.
It is such a game changer when a defendant is able to bond out of custody to fight from the outside. I mean, hey, look, when I have clients who are in custody, I can't send them an email for urgent information. I can't shoot them a text. I can't have this ongoing flow of communication. On top of that, I have to go and like submit physical documents to them for them to review. Takes them some time. They call me a week later and say, hey, I looked at this. Here's my feedback. Whereas all of that can be done in 20 minutes if the person's out of custody. So it can bring the representation to a snail's pace when the individual is in custody. And a lot of folks just simply do not have the opportunity, the financial resources like this defendant did to be out of custody and fighting it with full force.
Yeah, and we'll see what happens next. Certainly a new development. Makes things a little bit more complicated just kind of going through the court documents and figuring out the type of punishment, if any, this woman could end up facing. But certainly very interesting story. We'll see what happens next. Eric Faddis, criminal defense attorney from Colorado. Thank you as always for taking the time to be with us on Law and Crime. We appreciate it.
Thanks for having me, Chris.
Hogan will be back in court December 23rd in her perjury case on the attempted murder charges. She's slated to be back in court in January. That will do it for On the Case, presented by Law and Crime. Subscribe to us on YouTube and Spotify. I'm Chris Stewart. We'll see you next time.